officially start this meeting. Ladies and gentlemen, dear friends, welcome to this beautiful webinar organized by the Italian, Spanish, Portuguese Sports Lawyers Associations in cooperation with the ISDE Madrid, the SSBM School of Geneva, the University of Bergamo, and the Collegio Europeo di Parma. It's a true pleasure to have you with us. And if you allow me, I give you immediately the floor to the presidents of the three associations who organized this meeting. Miguel Ángel, the president of the Asociación Española de Derecho Deportivo. Miguel Ángel, please, the floor is yours.
Good afternoon from Madrid, and as president of the Spanish Sport Lab Association, I read everyone. Thank you, Michele. The judgment we will analyze today represent a revolution and challenge for our sector. Thank you to the speaker for the valuable analysis and to the attendee for their interest in this conference. All the best, everyone. Please, Esther, Vice President, Spanish Association, Michele.
Thank you, Miguel Ángel. Esther Geraldo, my angel in this webinar. Please, Esther.
Buenas tardes, good afternoon, también desde Madrid. Muchas gracias en nombre de la Asociación Española. Hemos tenido la oportunidad de colaborar con la Asociación Italiana y la Portuguesa en esta sesión para analizar 3 sentencias que sin duda impactarán en todo el deporte en todo el mundo. Gracias a los asistentes, muchas gracias a los speakers y esperamos que sea de vuestro interés.
Muchas gracias. And now, Salvatore, our beautiful president of the Italian Sports Lawyers Association, please.
Hello, Professore. Good evening to everybody. I am so happy to welcome all the colleagues who are now connecting to take part, to be present in this first webinar. I believe it's the first event organized to discuss about the recent decision about the Superleague. It's a pleasure for our association to co-organize. Of course, my special thanks goes to you, Professor, for having organized everything in these days. This event is another occasion for the association to strengthen more the international network of which we are proud to be part. Thank you so much and enjoy the webinar.
Thank you so much. Just to say, this is not the first event on these judgments, because the first event was beautifully done by our friend from Law in Sport, Sean Cottrell, our friends from EU Sport and the Asser Institute, the very same day of the judgments, in a beautiful manner. Chapeau. And now the floor goes to our friend, the president of the Portuguese Sports Lawyers Association, Jose, please.
Hello, everyone. First of all, I would like to compliment and to give a great, huge hug to my friend Michele Colucci, also to our friend Salvatore, Miguel Ángel, Esther. I think I can treat you like that because you are friends. Like I have said before, it's my last act as a president of the Portuguese Association, and it will be great to join with all these people and the honorable speakers we have to discuss the things and this problem. I think Portuguese is the most responsible country on this issue because it's the one that don't have any club on the Super League. We are responsible, but I can't not say the same from your country. Of course, I'm joking. Bye-bye, enjoy, and we'll keep in touch.
Thank you so much, dear President, dear Jose. And now, without any further ado, we go immediately in the hot topics of this webinar. And we expressly asked our speakers to answer in a practical way to the main issues of the 3 judgments of the Court of Justice. What does specificity of sport mean? How should we deal with the specificity of sport when we interpret, apply EU law? Do we have one or more European sports models? Is the European sports model static, dynamic, like the advocate Rantos was saying? And what does it mean? What is the impact of the home ground player rule judgment on clubs, on players? What is the impact of the Superleague case on the federation, on leagues, on third part, economic parts? And finally, what is the impact of the ISU case on CAS, on the arbitration clauses, the way they are written and implemented by the federations? It's with a lot of pleasure that I give the floor to our friend and colleague, Maria Carmen Perez González. Maria Carmen, the floor is yours.
Buenas tardes. Good afternoon, everyone. First of all, I will share my screen because I have some slides just to, let me see if I can do it. Oh.
Does it work?
Yeah, it will. Okay, can you?
Yes, please, go ahead. Fantastic, go ahead.
Okay, so first of all, I would like to thank Michele Colucci and the Sports Lawyers Associations of Spain, Italy, and Portugal for having me today and inviting me to participate in this webinar. It's truly a pleasure for me to engage in discussions with my colleagues about some of the implications of these judgments. In my presentation, I will focus on three particular aspects of the Superleague judgment. First, I will analyze the considerations made by the European Court of Justice regarding Article 165 of the Treaty on the Functioning of the European Union and some of the consequences that these considerations made by the European Court of Justice could have for the development of the European sports policy in the future. Finally, I will try to concentrate on what can we expect from the judgment within the framework of the proceeding in Spain. So we go first to Article 165, and why is this question important? I think the starting point should be the idea that the European Union is an international organization of integration whose functioning is based on the principle of the attribution of competencies. And as a consequence, the EU can only act in accordance with the competencies that have been attributed to it and to the extent to which they have been attributed. In the case of sport, since the Treaty of Lisbon, Article 6, letter E, provides that the Union has competence to carry out actions to support, coordinate, or supplement the actions of the member states in the area of sport. And in this context, what Article 165 does is specifying both the objectives assigned to the Union action in this area and the means which may be used to contribute to the attainment of these goals or objectives. And in this regard, the Court of Justice, the European Court of Justice, makes two main considerations. First, it says that the drafters of the treaties, when they wrote the text of the treaty, intended to confer a supporting competence on the Union, and this is nothing new. So far, we knew that from the wording of the article, allowing it to pursue not a policy, it says, as provided for by other provisions of the treaty, but an action in a number of specific areas, including sport. And second, the court says that this article 165 is not a cross-cutting provision having general application. Well, the truth is that many of us were not aware that the sport did not constitute a policy of the EU, and the same can be said, I think, for other EU institutions. As you can see in the slide, the European Commission, the Council of Ministers, and the European Parliament have referred to European sports policy at different times in different instruments or EU documents. Regardless of what this distinction may imply in the future, which is not certain, I could say, the truth is that from an intuitive standpoint, there is not a contradiction between a policy and an action, since a policy could be seen as a coherent and structured set of actions in a specific area, in our case, in the field of sport. But what are the consequences of this categorization for the European Court of Justice? First, according to the court, the incentive measures and recommendations adopted according to Article 165 need not be integrated or considered in a binding manner in the application of the rules on the interpretation of which the referring court is seeking guidance from the court. Second, Article 165 must not be regarded as being a special rule, exempting sport from all or some of the other provisions of primary EU law liable to be applied to it or requiring a special treatment for sport in the context of that application. But sport is different, it is specific, and carries considerable social and educational importance for the Union and for its citizens, and retains some specific characteristics, and these may potentially be considered along with other elements, and provided they are relevant in the application of EU primary rules. So in my opinion, even though nominally I understand it may seem like a devaluation, being a policy and then suddenly you are an action, but it doesn't appear to entail any substantial change for the rest of the EU institutions when exercising the competence attributed to them by Article 165. And in reality, not even for the European Court of Justice itself, which when applying those general considerations to the specific case, doesn't seem to do anything other than reaffirm its previous case law, as you can see from this slide. And finally, because I don't want to consume more than 10 minutes, I will try to say something about what is next at the Spanish level. Well, probably it is too soon to know, but there are some elements that maybe we can take into account at this point. First, I think we have to take into account to consider the nature of the preliminary ruling procedure. We are talking about a mechanism of cooperation between the European Court of Justice and the national courts of member states. And the main aim of these mechanisms is to ensure the effective and uniform application of EU law. But the European Court of Justice does not resolve the domestic dispute within the framework of which the preliminary questions are raised. In the case of the Superleague, the European Court of Justice is clear, very clear, in stating that the judgment does not address the specific project of the Superleague, but general questions regarding FIFA and UEFA rules. And it further emphasizes that this competition, the Superleague, is a competition that does not necessarily require authorization. So this is something that the Spanish judge will have to decide, whether when applying the judgment of, or in application of the judgment of December 2023, the project should be authorized or not. And this is something the European Court of Justice recalls at various paragraphs several times in the judgment. The second question is, are we talking about the same project we had at the beginning? Because any changes made in the Superleague's project design imply that the implementation of the European Court of Justice judgment will have to take place in a different context. Maybe we are talking about a different competition, and we are talking about a different set of authorization rules. So we will have to see how the procedure unfolds in practice and how these potential changes are raised within the Spanish procedure. as the effects of the Spanish judgment will depend on it. And finally, I think we have to take into account that once the Commercial Court number 17 of Madrid issues its judgment, any of the parties may file appeals against it. And if new doubts arise about how the European Court of Justice judgment should be interpreted, these new courts may raise new preliminary questions. So it is feasible that we will have new intervention of the European Court of Justice. So I think everything is, or almost everything is still open. And I don't want to consume more time, so I will stop here. And thank you very much for your attention. I will be happy to join the debate afterwards.
Perfect, Maria Carmen, thank you so much. As you also beautifully said and wrote, it's too soon to know. If the attendees, the panelists agree, we go further with the other panelists, and then of course the panelists can intervene on the intervention of the others, but also the attendees can of course intervene. Salvatore, please help me in spotting the question of the attendees, because you know I'm not very good at it. Carmen, muchas gracias.
De nada.
Bravo. And now, with also a lot of pleasure, I give the floor to Antoine. Antoine Duval. Everybody knows him. I think Antoine, since he was involved in the beginning of the cases, because he wrote so many things about sports law in general. In this case, in particular, and he has only 10 minutes. We expressly asked him to focus on the impact of the issue case on CAS and on the arbitration clauses. I think this is one of the main interests that our attendees have. But of course, dear Antoine, the floor is yours. Integrate your intervention as you wish. And thank you so much for being with us. Please.
Thank you, Michele, and thank you to all the others, the other organizations for inviting me. It's a pleasure to be here. Indeed, I want to claim priority, as I didn't really stop reading those judgments on the day to feed our first webinar that took place on the 21st, directly to comment à chaud, we would say in French, on the decisions. I must say, now I have had more time to digest them, so it's also a different perspective that comes to the fore. So I'm really happy to have that opportunity to rehash a few findings or a few conclusions that I drew on the day. Indeed, as you mentioned, I was, and I need to disclose that obviously, I was with my friend and colleague Ben van Rompuy at the origins of the ICU case, which started in this office at the ASE Institute with a complaint that was lodged almost exactly 10 years ago with the Commission. And part of the complaint, but a rather minor part in my view at the time, and I think more of an incident dimension of it, was challenging the binding CAS arbitration clause. And in fact, we didn't know at the time, but this has now become probably one of the main specific legacies of the ICU judgment. Indeed, as the overall framework that will be discussed about the distinction between object and effect and the role of 101.3 versus the Wouters test is shared between all the three decisions. The main specificity that we see in the ICU judgment concerns the CAS. And let me go back a few years to the EC decision to remind you a little bit what was the original decision of the Commission regarding to CAS. it was that the hurdles that the appeals arbitration rules impose on athletes in obtaining effective judicial protections against potentially anti-competitive and eligibility decisions of the ICU reinforce the restriction of their commercial freedom and the foreclosure of ICU's potential competitors. It was this conclusion that led to CAS becoming part of the discussion nowadays. And this is due mainly to the General Court's ruling, which annulled that specific part of the decision. It was the only aspect on which ICU prevailed on appeal against the decision of the Commission. And the General Court recognized that the binding nature of arbitration and the fact that the arbitration rules confer exclusive jurisdictions on the CAS to hear disputes relating to decisions on ineligibility made by the applicant may be justified by the legitimate interests linked to the specific nature of the sport. And supported that view as well with the fact that the skaters could bring, if they so wish, in accordance with the case law of the court, an action for damages before a national court, or could bring a case before a national competition authority or the commission, as we had done in the case of ICU. So the conclusion of the General Court was that the CAS arbitration was not as such as to compromise the full effectiveness of EU competition law, and therefore the General Court annulled the EC's decision on that point. In this regard, again, mistakenly in retrospect, but Hgprstill was really the main loser of the three cases, probably. It was fully endorsed by the opinion of Hgprstill, who went even beyond in his assessment of the importance of CAS arbitration. In his opinion, he mentioned that the binding nature of arbitration and the fact that the arbitration rules confer exclusive jurisdictions on the CAS to hear disputes relating to decisions on ineligibility may be justified by legitimate interest linked to the specific nature of sport, and that while there may indeed be an asymmetry of powers between a sports federation and athletes, I am of the view that provided that, on the one hand, the independence and impartiality of the CAS are not called into question, and that, on the other hand, recourse to CAS arbitration can be justified by legitimate interests, such an argument against the CAS cannot succeed. So here we had both the General Court and the IJ basically siding partly with the CAS, recognizing that there need to be a way to challenge and to obtain damages ex post, but that the CAS arbitration clause is per se binding. And this is what the Grand Chamber overruled in its decision on the 21st of December. And first, it stressed that the specificities of sport cannot justify that a disregard to the requirements that must be satisfied for an arbitration mechanism such as that at issue to be capable of being regarded on the one hand as allowing effective compliance with the public policy provisions that EU law contains to be ensured, and on the other hand as being compatible with the principles underlying the judicial architecture of the European Union at paragraph 188. And it specified that point by making clear that the core focus of the Grand Chamber is not really the CAS itself. The Grand Chamber didn't really discuss the independence of the CAS, as it wasn't raised before the General Court. We had pushed for that in the counterclaim, but we didn't get to that. Nor did it discuss the fact that this is forced arbitration as a problematic issue. The main problem lies not in the intervention of the CAS, but in the review, but in the fact that they subject the review of the arbitral awards made by the CAS and the last instance review of decision of the ICU to the Tribunal Fédéral, the Swiss Supreme Court. That is to say, a court of a third state. The fundamental problem for the Grand Chamber is therefore that the ultimate review of a CAS award is conferred to a court that mainly cannot make a preliminary reference to the Court of Justice to assess whether an award is compatible with EU mandatory law, in this case, EU competition law, EU public policy. And this is particularly necessary, and this is also an important part, an important paragraph of the judgment, paragraph 193. This is particularly necessary when such an arbitration mechanism must be regarded as being in practice imposed by a person governed by private law, such as an international sports association. So the fact that this is forced arbitration becomes relevant in this context. And this is an important aspect to keep in mind. The Grand Chamber also rejected the 2 points of the General Court that access to effective judicial review was secured through ex post review by the courts in damage claims, or through the possibility to raise a claim before a competition authority. So this is enshrined in paragraph 198 and 200 of the judgment. So basically, let me turn now quickly to what I consider are the implications for the CAS and beyond. First, for ISU will have to amend its appeal arbitration rules to allow direct challenges before national courts, or if it doesn't, the validity of its CAS arbitration clause will in any case be rejected by national courts if a dispute involves EU competition law and EU free movement. For sports governing bodies in general, CAS arbitration clauses have lost bindingness, at least in disputes involving the compatibility of their decisions, their regulations, with EU mandatory law. And here, EU public policy will start to play what is included. The scope of EU public policy will start to become very important. At this point, we can say that EU competition law and the free movement rights are both almost certainly, for the free movement rights, we haven't had a case yet, but it seems difficult to accept that they wouldn't be considered public policy, are most certainly part of it. Maybe other parts of EU law could also be included. And the sports governing bodies must therefore be prepared to face a greater number of challenges in less friendly courts at the CAS, the member states' courts, on the basis of EU competition and free movement law. For athletes, clubs, managers, supporters, stakeholders, if you want to go after the regulations decision of sports governing bodies, get a lawyer with an EU competition law background. More seriously, the strategic decision of going to CAS or going to a national court to challenge a sports governing body becomes central, because the latter is not such a difficult and remote alternative anymore. It has become easier to get and challenge a sports governing body directly before a national court. And here it's interesting to note the focus and the stress put, for example, by the Grand Chamber on protective measures, on measures that are supposed to be taken quickly by national courts in competition law cases. In practice, a lot will depend now on how strictly the national courts interpret the application of EU competition law to the sports governing bodies, on how strictly they apply the object-effect distinction, and they consider the justifications to regulations of sports governing body under 1013 or the Wouters test. So here there is an interaction between the impact of that part of the ISU judgment and the more general impact of the ISU Superleague and Royal Antwerp case on the framework of assessment of decisions by sports governing bodies. So from the perspective of challenger of sports governing bodies, the cost-benefit analysis of choosing CAS over national courts of the member states is now less favorable to CAS. In general, we can say in the abstract. What is the consequence for the CAS? Well, it will become easier to bypass the CAS in controversial cases on the basis of EU law challenges, again, grounded in free movement or competition law at least. The CAS, in my view, will have to make the case now more than ever for its attractiveness to athletes and clubs. That means it will have to prove The proof will be in the pudding. You cannot rely anymore on the bindingness of the clause. You're going to have to prove that you are faster and cheaper than national courts. You're going to have to prove that you're less structurally biased towards sports governing bodies. The CAS will have to prove that it takes EU law and European human rights law seriously. Because if it doesn't, then clubs, players will start to flee, will start to try an alternative road, which is to go to national courts. The silver lining for the CAS in the judgment is that, again, the validity, the legitimacy of CAS arbitration in itself is not questioned by the Court of Justice, nor is it endorsed, but it's just not touched upon. And I think this leaves a lot of opportunities for the CAS to continue to operate. If the CAS will want to close that possibility to escape the bindingness of CAS arbitration, the only way at this point would be to relocate the seat of the CAS in an EU member state, basically join FIFA to Paris. That would close that loophole because the CAS awards would then be seated in France and reviewed by the Cour d'appel de Paris. Again, that would be an option. I'm not sure that this will happen in practice. I'm actually pretty sure it will not happen in practice because the CAS might very well be able to continue to attract a sufficient number of cases still being seated in Switzerland, thinking of anti-doping cases, which will be difficult to challenge before EU member states courts because of the Mecca Medina decision, or cases involving the RSTP. This is the bread and butter of the CAS caseload. And these cases are not necessarily likely to be moved to EU member states courts. So there is a high chance for the CAS to operate in parallel with more cases going towards member states of, towards courts of the member states of the European Union. And finally, what is the consequence for the Swiss Federal Tribunal? Well, the judgment is quite a slap in the face from the Court of Justice to the Swiss Federal Court, saying basically, we cannot entrust you. We cannot trust your review for matters of EU public policy. And in a way, this is fully deserved. The Swiss Federal Tribunal refused to review arbitral awards on the basis of EU public policy, of EU competition law. But it's also impossible to mitigate because the court has made it conditional to the possibility of sending a preliminary reference to the court. And in this case, the only solution would be for Switzerland to join the European Union, which I don't think is very realistic in the short term. So I think, and in this regard, this is another warning shot for the Swiss Federal Court. European courts, be it the Court of Justice or the European Court of Human Rights, are getting very tired of the lenient review of CAS awards by the Swiss Federal Court. I remind you, 2022, all challenges against CAS awards were rejected. And this is not unusual. This is just not compatible with the specificity of CAS appeal arbitration, its forced nature. If the Swiss Federal Tribunal Swiss Federal Supreme Court does not address this issue fast, it will probably face increasing criticisms and distrust from outside Switzerland. Thank you very much.
Antonio, thank you so much, because actually I think you really touched all the aspects related to the impact of this judgment of the Court of Justice on CAS, on the sports stakeholders, federations, clubs, and athletes. Let's say like that. I mean, this judgment have given the possibility now to everybody to reflect about, you know, the possibilities to take into account actually the public policy, the EU fundamental principles of law. Of course, I mean, I'm curious to see how it's going to develop, but of course, I mean, this judgment judgment, for sure is going to have an impact on everybody. I'm sure that we'll have a lot of questions for you. I want to just continue with the other panelists, but thank you so much, dear Antoine. And now it's also with a lot of pleasure that I would like to give the floor to our friend and colleague Richard Parrish, to whom we asked to deal with the judgment on the Football Club Antwerp, on the UEFA home ground player rule. Also because Richard, several years ago, with one of the rapporteurs or the writers of a report on the UEFA home ground player, I'm sure that he is the right person to tell us what the consequences of this judgment on the sports world. Richard, thank you so much for being with us, and the floor is yours.
Thank you, Michele. Yes, it was such a long time ago that I co-authored that report with some colleagues from universities of Liverpool and Loughborough that I almost forgot that it exists. And then the Belgian court reminded me of its existence. I'm very grateful to the Belgian court. Yeah, so on the Antwerp case, I guess, as is the case with many of these issues, all roads lead to Bosman. And you will remember in Bosman, the court condemned the nationality quota system, the 3+2 system that operated at the time. And UEFA observed that this had a number of negative impacts, particularly on competitive balance in European football, but also on the issue of incentivizing youth development. And so from the 2006-07 season, UEFA introduced the homegrown player rule, and which basically, when it was fully implemented, meant that within the 25-player squad, at least 4 players needed to be so-called club trained, and the remainder could be association trained, so trained by another club in the same national association. Now, many national associations introduced or imitated UEFA's rule, and Belgium did likewise, but varied it somewhat in the sense that within the Belgian system, all 8 players could be sourced from association-trained clubs. I've got 4 observations to make very briefly about the judgment in Royal Antwerp. The first is on the question of the admissibility of the questions, and that was referred by the referring court. And across 20 paragraphs, the court actually justified why the referral was admissible in its entirety. And I think we should remember that this dispute originated in the Belgian Court of Arbitration for Sport. And so this does show that the European Court is capable of asserting EU law-derived rights in the assessment of arbitral awards, noting Antoine's discussion about ISU, albeit, of course, from a European jurisdiction. Now, I think that the court's receptiveness to answer these questions certainly raised my expectations that the issue was going to be definitively decided in Luxembourg. But the court then said that it's really for the referring court in Belgium to undertake the detailed examination of the compatibility of the rule with EU competition and free movement laws. Now, I guess at one level that's to be welcomed, and it has a logic, because if sporting autonomy is to be genuinely conditioned on good governance practices, then we do need a detailed assessment of them. And in this regard, the court did say that UEFA and Belgium would need to bring forward, to quote, convincing arguments and evidence. That's, I think, what many of us have been asking for many years. The risk, of course, is that the national courts will come to different views. And what we need, I think, is a harmonization of governance standards in an upwards direction. We thought that was the role of CAS, and maybe, speculating, that could become the role of a new EU agency, noting, of course, the current UK or the pending UK legislation on the creation of an independent football regulator in England. So I think the move towards some form of European-wide regulator might become a little stronger. Now, my second observation is on Article 165. I'll deal with this only very briefly because Carmen has already mentioned it. We all know that Advocate General Rantos thought that sought to expand Article 165 in Superleague, but in Royal Antwerp and indeed in the Superleague judgment itself, the court declined that invitation. The court said that the article is not a cross-cutting provision having general application. and therefore need not be integrated or taken into account in a binding manner in the application of Articles 45 and 101. So we might come to the conclusion that's rather bad news for the governing bodies, but really is it? And I think Carmen's already touched upon this. The court went on to say that sport, to quote, undeniably has specific characteristics and that these can still be taken into account. So rather curiously, the court is saying that sport can be special in adjudicative terms, but maybe not so special in constitutional terms. Now, the part of the judgment that I took some issue with was an issue that Carmen has already discussed, and this is the court preferred referring to the word action rather than a policy on sport. I think this seems a little overly pedantic, and I worry that it will give rise to conservative thinking, but particularly with those who work in sports policy within the European institutions. And it will infect not only the sporting provisions, but potentially also those of other supporting competences within the treaty. We'll have to look out for that. My third observation is regarding competition law 101. Now, of course, the main surprise is that the Mecca Medina's inherent rules doctrine has been restricted to restrictions by effect and not object, and this is going to be the subject of discussion a little later. So I won't mention it more than I have done. So the question then turns to whether or not the homegrown player rule restricts by object, and I don't think it does, but it's not for me to decide that. It's for the referring court to establish this. To me, the rule does not seem to present such a degree of harm to competition, and the market is not, in my view, completely partitioned along national lines. Although the UEFA rule seems to be less offensive than the Belgian rule in that regard, because of the balance between the two rules, between the club-trained and the association-trained element. Therefore, we could make the argument that the restrictive effects of the rule are inherent in the pursuit of the objectives pursued, notably incentivizing youth development. Now, the inherency argument, I think it could be possibly undermined if one were to look at how UEFA competitions thrived prior to the introduction of the rule. There doesn't seem to be an existential threat to UEFA competitions, for instance, by not having the rule. But if a national court were to establish that there was a restriction by object, then it will be the 1013 exemption criteria that will possibly save it. And here, of course, the referring court will need to assess whether or not the rule promotes efficiencies and benefits from those efficiencies, and whether the rule is suitable and necessary. And I think here the court, the referring court, will need to assess the possibilities offered by less restrictive means, and that may give rise to a discussion that we could have as to what might those less restrictive means be. I mean, we could look, for instance, at a strengthened licensing system, or some form of incentivized payments for developing young players, or some form of direct compensation. My fourth and final observation regards Article 45. It'll not surprise you to discover that the court found that the rule is indirectly discriminatory and therefore requires justification. This is what we were arguing in our report many years ago. In that regard, the court wants to see evidence that the rule really does incentivize youth training. And in doing so, it seems to cast doubt on the association-trained element, as indeed did Advocate General Spooner. Now, where is the incentive, I guess, for a team with significant financial means to invest in youth development if they can buy, essentially, half or even the entire homegrown quota from clubs in the same national association? And that's the level of scrutiny that the referring court will have to enter into. So, Michele, I said I would be short. That's it. I'm looking forward to having a chat about these issues in due course.
Thank you so much, dear Richard. We are already receiving questions. I would just want to finish the first round, and so then we will answer to all these valuable questions. Thank you so much. I have also a lot of questions to you, Richard, but let's move on. Now it's a lot. It's a lot of pleasure. Please allow me to say this: that I give the floor to my companion in this beautiful trip through the European Union sports law, Stefano Bastianone, with whom I'm developing several aspects of this fascinating field of law. Stefano, it's a lot of pleasure that I give you the floor to focus on the Superleague case, its impact on the federation, knowing that Stefano is a professor of competition law, European Union law, and sports law. Please, Stefano, the floor is yours.
Thank you very much, Michele. Let me try to share the screen because I have some slides. Don't worry. I've prepared. Okay. Well, I will briefly focus on three legal issues. And these issues are the notion of purely sporting rules, the restriction of competition by object, and the scope of the Wouters Mecca Medina O2C case law. The aim is to just share with you some ideas for the debate. The notion of purely sporting rule is not new. In all three cases, the court says that insofar as the sports constitutes an economic activity, it is subject to EU law. But then it says that only certain specific rules adopted solely on non-economic grounds and which relate to question of interest solely to sport per se must be regarded as being extraneous to any economic activity. As I said, there is nothing new in this definition. If we go back to 1974, at the origin of the European case law on sport, in the Warav and Koch case, you can see a similar definition. The purely sporting rule is defined as a rule which is enacted for question of purely sporting interest and as such has nothing to do with the economic activity. So what is the relevance of such a reference in the 2023 ruling? The reference is the Mecca Medina case 2006. In that case, the Court of Justice said that the case was about anti-doping rules, and the Court of Justice said that even if anti-doping rules concern questions of purely sporting interest and as such have nothing to do with economic activity, which I translate, even if anti-doping rules are purely sporting rules, that fact does not mean that the rules in question necessarily fall outside the scope of former Articles 81 and 82 of the treaty. And the same concept has been repeated in the white paper on sport by the Commission, where the Commission said that the notion of purely sporting rule is irrelevant for EU competition law, and more generally for EU law. Just to be clear, the Mecca Medina case and the ruling has been highly criticized, and personally speaking, I'm happy to welcome back the notion of purely sporting rule. However, I find it difficult to fully understand the reason behind such an exhumation, let me say, of the purely sporting rules in three cases where none of the rules at issue can be regarded as purely sport. Second topic, restriction by object. We can say that the court's reference to the notion of restriction by object marks the most striking, one of the most striking differences compared to Ranto's opinion. If you look at paragraph 73 of the Ranto's opinion, according to General Advocate, the lack of transparent, objective, proportionate, and non-discriminatory criteria cannot automatically entail classification as a restriction of competition by object. By contrast, at paragraph 178 of the Superleague ruling, the Court of Justice says that where there are no criteria which are transparent, objective, and non-proportionate and non-discriminatory, this fact reveal by their very nature a sufficient degree of harm to competition and thus have as their object the prevention of competition. However, if I can say, I think that paragraph 176 of the Superleague case is even more important. In such a paragraph, the court says that to confirm that the UEFA rules are restrictive by object, that UEFA rules make it possible, if not to exclude from the market any competing undertaking, at least to restrict the creation and marketing of alternative or new competition in the terms of the format or content. And immediately later, it says, however, such innovative format must comply with all the principles, values, and rules of the game underpinning the sport. So we all know that in terms of competition law, the possibility for the newcomer to differentiate the product is of paramount importance. So if you read paragraph 176, it seems that the Court of Justice is admitting the possibility to create alternative or new competition in terms of the format or content. However, the question is it possible to organize a new competition and differentiate it in terms of format, let's say a semi-closed league or a closed league, and or in terms of the rules of the games? Let's imagine the number of substitutions, no throw-ins, no goal kicks, and stuff like that. And another question is, what are the principles and values of the game underpinning the sport? What sport? What are the principles and values of football? The ones mentioned in Article 165, although this article refers to sport in general, I really don't know. The last topic is the non-application of the Wouters, Mecca Medina, and Otok case law to restriction by object. To support this argument, the Court of Justice makes the following syllogism. According to paragraph 53 of the Motu judgment, it is implicitly but necessarily apparent that Wouters and so on does not apply to conducts which infringe by their very nature Article 102. Article 101 and Article 102 must be interpreted consistently. Therefore, Wouters, Mecca Medina, and OTC does not apply to restriction by object under Article 101. However, if you look at paragraph 53 of the Motu judgment, I really can't find that is apparent that the Court of Justice is saying that the Wouters test does not apply to restriction by object. In particular, then, look at the first element of the Wouters test. It refers to the economic and legal context of the agreement you must consider to establish the existence of legitimate objectives. And if you see the Superleague case, paragraph 165, and more generally settled case law of the Court of Justice, to determine whether an agreement is restrictive by object, it is necessary to examine, inter alia, the economic and legal context of which it forms part. So how can we reconcile these two apparent and contradictory statements? one thing, and I wanted to conclude. The principle laid down by the Court of Justice is totally new. In my view, it's not supported by any precedent, and it is rather questionable insofar as it does not refer only to the specific sports sector, but it is a principle of general application. The principle applies to all restriction by object, regardless of the economic sector where they take place. So from now on, when we explain Article 101 to our antitrust students, not only sports law students, we must remember to explain them that the Wouters test does not apply to restriction by object. And if they ask us why, to be honest, I'm currently unable to find a good answer other than quoting the relevant paragraph of the rulings. So, no doubt, the three rulings are important for the sports sector, but if I can say, I think they are even more important for competition law. I stop here. I thank you all, and I'm of course available for any question. Thank you.
Thank you so much, dear Stefano. Your presentation is the perfect assist to introduce our honorable guest, dear friend, Professor Massimo Coccia, who is an experienced CAS arbitrator. I would say an experienced arbitrator, first of all. Then also CAS arbitrator, professor of competition law, EU law, and sports law. Is a huge experience. I had the pleasure, the privilege to co-edit a book together with him, and I learned so much from him, also by doing this simple exercise. And to Massimo, we would like to ask indeed, what is his opinion about this case? What is the impact on the governance of the sports international and national sports associations? Dear Massimo, please, the floor is yours.
Thank you, Michele. Very, very kind, your presentation. I'll try to, actually, I'm focusing on 3 points. I'll try to be very brief. The first point is about the fact that this is, in particular, I'm focusing on the Superleague judgment. It's a decision of football. I think that in reading the decision and digesting it, there are several passages of the decision where the court makes it clear, not as clear as Advocate General Rantos, who explicitly say that other sports might have different features. Here is more implicit, but it's quite, in my opinion, quite clear that it is referring to football. And for instance, in paragraph 105 of the Super League judgment, the court says that, specifically says that when there is an assessment that must be made of a rule adopted by a sporting association in terms of competition law or freedom of movement, etc., that need to take into account the nature, organization, and functioning of the sport concerned, and then specifically how professional it is, the manner in which it is practiced, the manner of interaction between the various participating stakeholders, the role played by the structures and bodies responsible for it at all levels. So that paragraph 105 is very significant. And then there are several other passages in the decision. For instance, 117, where it says, unlike the situation prevailing in respect of other sporting disciplines. Then at paragraph 143, say the sport of football gives rise to organization of numerous competitions at both European and national levels. And then it says, in common with other sports. So this means that there is everything essentially based on sporting merit, it says. And this means that obviously, of course, a contrario, as lawyers, we are accustomed to reason, means also that it is not in common with some other sports. And then again, 144 makes reference to the specific context, professional football. 147, specific attributes that characterize professional football. So what would we take from this? Well, first of all, as already was observed, maybe not today, but everybody who reads the decision can notice that the European sports model is not mentioned at all in the judgments, which is very good in my opinion, because this lends credibility to something that I've been saying for many years now, writing as well, that there is no European sports model in my opinion. There is a European football model. There is a European football model which also is adopted by other sports disciplines, but there are many important sports where the European sports model is not followed, or are several variations. Let's take, of course, many individual sports is the situation. This is the situation with golf, tennis, sailing, many motor racing, both in terms of cars and motorcycles. So in many individual sports, there is a very different model, but also in some team sports, we find a difference in rugby, we find a difference in ice hockey, which is a very important sport in many consider, like the Russian league, which by the way is not only Russian, there are also teams from other neighboring countries. The Russian league, they have, like, I believe the average in the last season was 25,000 spectators per match. I mean, so we're talking about big, also there's an important German league in ice hockey, and several transnational leagues as well in ice hockey, in basketball as well. We have the Euro League, which is a semi-closed league. So we have. So in my opinion, as I said many times, there is no European sport. There is a European football model, certainly there is there. And the fact that the court specifically mentions football, and so I believe we cannot apply directly the consequence of this judgment to all sports in terms of the Superleague judgment. At least a caveat must be done. Then second point I want to make is about the difference between this decision and the previous one. In particular, something that was already said in reality partially by Stefano Bastianon. The difference with the motorway case, which was the only previous case where the court had to deal with an authorization system, a prior authorization system by a sports organization, although the difference there was that there was the involvement of a Greek regulation, state regulation, and therefore was the facts were very different. But there, the court specifically mentioned as a limitation to the power to approve, to the power to authorize a sports event by an entity which also is on the market, was that that power should have been subjected to restrictions, obligations, and review. And that was it. That decision did not say anything more. In this decision, and this not only in the Superleague, but also in the ISU judgment, it goes much beyond that. It takes almost a regulatory approach, the Court of Justice, by specifying that even that the characteristics of the authorization system, going even beyond that, talking about even some substantive aspects, not only the procedural aspect. We know specifically the fact that the procedure must be transparent, objective, predetermined, subject to a review by effective judicial review, which, by the way, I open a parenthesis here, subject to effective judicial review means, in light of the ISU judgment, that cannot be the case, may not be the case. In particular, so any authorization procedure will have to be subject to a court in a member state, by the way, because even I believe that what the court said with reference to, because as correctly Antoine pointed out, the criticism is actually to the Swiss Federal Tribunal. And in fact, they had certainly the 10 Sacchai judgment. For those who know the jurisprudence of the Swiss Federal Tribunal, the 10 Sacchai judgment is the infamous judgment where the Swiss Federal Tribunal say, well, it's not competition law is not part of public policy. In general, not only EU competition law, but also Swiss cartel. The Swiss Cartel Act is not part of public policy. Anyways, so because of that criticism to the Swiss Federal Tribunal, I believe that even a judicial review putting as a choice of forum the Swiss Cantonal Court of, for instance, of Lausanne would not, or Geneva or whatever, would not be good enough, in my opinion. So this is interesting. Not really, now I'm not talking really about sports law, but it's more interesting in general, thinking about the Lugano Convention, because the Lugano Convention between Switzerland and the EU member states makes an apportionment of jurisdiction between the different, on an equal level, an equal footing between Swiss courts and EU courts. So I wonder how that convention is now compatible with this judgment. This leads me, so it takes a regulatory approach, really. And this leads me to the third point I want to make. The third point is a contradiction that I see in the Superleague judgment, and also, well, the ICU judgment is different because coming from an appeal, so it does not, it's mostly in the Superleague judgment. Where is the contradiction? Well, the court, as we all saw reading it, makes kind of a lesson of competition law. Of course, a very short lesson, reminding all the reasons why competition law must be protected. Some of those reasons are the fact that you must, the things that we say usually in my competition law course, I say it in the very first lesson, of course, that it must promote innovation, improvement, improved quality of products and services, and so giving the possibility to launch new products, new services, new ideas, etc., etc. And here the court says that, makes that point clearly in several passages of the decision. For instance, a paragraph 133, I'm talking about the Superleague, saying that the fact itself that there is an organizing of competitions, which is a gatekeeper, there is a big conflict of interest there, and this goes to the detriment, because a conflict of interest which could prevent the establishment of an alternative organizer, and that, says the court, goes to the detriment of consumers by limiting production, product, or alternative service development or innovation. So this is the manifesto typically of what competition law is about. But then when it gets to, and Stefano already pointed that out, when it gets to talking about the authorization system, it starts saying that it must protect some values of football. In particular, at some point, it says specifically that among the policy objectives, public interest objectives, says public interest. It's a very strong point, paragraph 253 of the judgment, Superleague judgment, consisting in ensuring prior to organization of such competition that they will be, and they will be refers to the alternative competition that need authorization. They will be organizing observance of the principles, values, and rules of the game underpinning professional football. As Stefano says, we don't know, but then he says in particular the values of openness, merit, and solidarity, but also that those competitions will, integrate into the organized system of national, European, and international competition. So I see a contradiction there because, as already Stefano mentioned, in order to launch a new event, you also need to differentiate that to have some innovation. So why not, talking about football, why not timeouts, for instance, that already we have the cooling break, which becomes a sort of a timeout, to have the coach have 1 minute like it happens in other sports to talk to the players, or to have other forms of innovation like we have in rugby, you know, that players can be just have a temporary for 10 minutes, a temporary ejection from the game, that they can come back, or the possibility that also it happens in some circumstances in rugby that some players that are substituted can come back to the pitch. I'm just mentioning a few examples, but reading the decision here, it seems that it is already limiting, in a way, seems to be limiting the possibility to innovate for an alternative event organizer, which is strange, given that all those criteria that are mentioned, the substantive and procedural criteria, you know, the non-discriminatory, the transparency, all those requirements are there in principle to limit the arbitrary power of the entity of the sporting association authorizing the alternative event organizer. So if it becomes a kind of a way to, and already a way to limit the possibility to have an alternative, really an alternative event, there is a very strong contradiction. I'm curious to see, and Carmen said it correctly, that there might be a new preliminary reference to the court in the following stages of the Spanish judgment, or in other countries for other litigations, because in fact here I don't see it very clearly how it can develop, because if you read the authorization regulation already enacted by UEFA, for instance, among the criteria to be authorized is to strictly follow the IFAB rules of the game. IFAB is the entity which enacts the rules of the game of football. And so the ideas that I put there, just speaking, you know, chatting before, they could not be implemented, for instance. And that's an important part of a competition. Then in terms of format, as Stefano mentioned as well, does that mean that you need to do exactly the same competition already on the market? I think in terms of competition law, that's a big limitation. That's why I said before, it took some kind of a regulatory approach, the court, in doing that. And in my opinion, it exceeded a bit what it should have done. I much prefer the motorway approach, where it simply say that you need to have, you know, restrictions, obligations, and review, without going too further on that. And with this, I stop. I hope I did not exceed the time allowed, and I might get back in the discussion later on. Thank you.
No, thank you so much, Massimo. Thank you. Actually, innovation was my key message, and now that, you know, after your presentation, now I have a lot of doubts, because I was convinced that these judgments gave room for innovation. But watch out, not only to the third entities, but also to the existing one, to the federations, to the leagues. I mean, I think this should be interpreted like taken as a prone, an incentive to think out of the box, to think of all the possible alternatives in terms of format, content, and so on. And I did not reflect on this specific point that you rightly raised. I see there are several questions. I just try to regroup the questions by issue. I think that we have two questions concerning CAS. Antoine, I don't know if you are able to read the question. Do you want to do you want to answer the questions for you? I think everybody can read it. So I mean,
yes, I'm happy to do it.
Yeah, the first one from Cambyse concerning, you know, the possibility to change the ICA statute for the composition of athlete-friendly members.
Let me start by not responding, but by addressing a point that Massimo raised, and I think we also addressed it a little bit in preparation of this webinar, about the potential impact beyond the sporting context, and of this decision also to commercial arbitration, because indeed the way one can read this judgment is as basically lifting the bindingness of arbitration clause across the board with regard to EU public policy, and potentially affecting indeed the operation of private international law as well through the Lugano Treaty in terms of jurisdiction. So I think there is a potential to read that judgment that way. I would just point to paragraph 193, in which the court stressed that allowing for the review of a member state's court is particularly necessary when such an arbitration mechanism must be regarded as being imposed by a person governed by private law, such as an international sports association, on another, such as an athlete. I think this part, to some extent, narrows the judgment, or can be read as narrowing the judgment to situations in which there is a forced arbitration, which would exclude commercial arbitration. So there, I think there will be a lot of debates in front of national courts around that interpretation, and that paragraph might play an important role to try to circumscribe the impact of the judgment to sports arbitration. Then turning to the two questions, first, Cambyse. Can the ICAS statutes be amended? Yeah, sure. In theory, it's possible. Will it be done in the short term? I would think that the CAS will prefer to wait and see at this point whether the challenges before national courts multiply, whether it stays attractive in its current form. If it does stay attractive, sufficiently attractive to have you know, a sufficient amount of cases to fund its activities, and then I doubt that any reforms will be introduced. If we see a wave of cases, and if sports governing bodies start to some extent put pressure on the CAS to reclose the loophole, we might see changes. It's again not excluded that we might see changes in terms of trying to raise the attractiveness of the attractivity of the CAS, or in the most extreme change would be to relocate the CAS. Again, I don't think this will be decisions that will be taken lightly. They will not be taken swiftly, but this depends a lot on also what complainants, whether clubs, athletes seize the opportunity to go to national courts to challenge sports governing bodies, and on how the national courts and the Court of Justice will react. If, and I think here that connects with the point of Massimo earlier, I think the judgment leave a lot of room in terms of interpretation on what is an object or an effect restriction, what is a justified restriction under 101(3). There are contradictory elements inside the different judgments pointing a different direction, which will probably need another intervention of the Court of Justice. So there is also a potential for that second round to, in the end, narrow down quite considerably the applicability of competition law in the sporting context, and then the incentive to use national courts would be hugely diminished. So there are a lot of unknowns in terms of the future implications, practical implications of that part of the judgment that make it difficult to predict what will happen. And regarding the question of Nicolas, maybe you want me to take it right away.
Yes,
as well. What is the immediate contractual consequence of the ICU decision with respect to arbitration agreements?
Yes.
The way I read the judgment, the CAS arbitration clause is not binding insofar as we are dealing with a challenge to a decision, a regulation of the sports governing bodies that is based on EU competition law or EU free movement law, meaning it cannot be opposed to a party going to a national court against such a decision or regulation. See Serin or Pechstein case. But it is still binding in a way. It's partially binding insofar as it concerns a matter that is not economic. So here we have again another Pandora box. What is economic? What is non-economic? It's a very big debate. Or if the challenge is not based on EU public policy, so competition law and free movement at least. So in short, the main consequence is that we cannot say that the CAS arbitration clause has lost totally bindingness. It has a kind of relative bindingness. It is binding depending on the nature of the dispute, the nature of the decision, and the type of arguments that are raised against a decision or a regulation of the sports governing bodies. We need to assess that in concreto. So that's would be my main, let's say, assessment of the impact of the decision of in the ICU of the court.
Very clear, dear Antoine. And I see that Massimo raised a point. I think that Durante, among the attendees, raised the hand. Durante, please write down in the chat your question because all attendees are muted. So please write down your question. In the meantime, I give the floor back to Massimo. Massimo,
yes, sorry. No, I don't read I don't see the questions, but anyways, the written question. No, just wanted to mention that in terms of the football, the FIFA regulations on the status and transfer of players, with regard to disputes between athletes or coaches with clubs, they already have an alternative choice of forum, because they can either go to the CAS or to a national court. It's up to the plaintiff to decide that. So players, they can choose that, and I see that there is an incentive to go to the CAS, because I've seen many cases of players or coaches preferring the CAS instead of having to litigate, I don't know, in China or in Qatar. So already there is that. And I wonder, in any event, whether this would satisfy the European Court of Justice requirement, because if the alternative national forum is outside the European Union, you would not satisfy anyway. So if there is, say, an Argentinian player and a Spanish club, if the Argentinian player chooses the Argentinian national course, for instance, they still would not satisfy the requirement that they could raise a 267 preliminary ruling to the court. So we'll still be back to square one, in my opinion. But in any event, I can see the appeal of arbitration in general. Then CAS, for many situations, like it happened to me as a lawyer advising sometimes some clubs or some even in commercial settings, not having to do with sports, that instead of litigating in a foreign country where you don't know very well the judicial system, or you're not confident that the judicial system is truly independent. For instance, you have to litigate against a state-owned entity. I'm not talking about sport. You might choose arbitration. So there still are several situations in which arbitration would still be a preferred way of settling a dispute. But with regard to the alternative choice of forum in the FIFA regulation, I don't know if that would satisfy the requirement of the court either. I have to think about it, frankly.
Thank you so much. Just to conclude on this arbitration clause, there is a short question. Thank you, Durante, who asks, after the issue arbitration clause, is there a need for the sports movement to review their domestic legal and jurisdictional system? It's open to everybody. If you have an opinion on this.
Well, I think there is a need for the sports governing bodies to be aware that they are at a higher risk of facing a dispute before a national court of a member state on the basis of EU competition or in free movement. And so they have to adjust accordingly in terms of preparing potential defenses to their regulations and decisions. I think that's the main takeaway from that judgment for the sports governing bodies.
Very good. And then we have, so we try to answer to all the questions in the last 4 minutes. We have the anonymous attendee who has a question for Richard. Richard, I don't know if you are able to read it. How do you think it will ultimately play out before the Belgian court? Do you think the evidence has dramatically changed since 2013 in a way which would indicate that the rule is achieving its objective of incentivizing the training and development of young players? Will the association-trained element need to be abandoned, as the Advocate General suggested, or do you think the whole rule is doomed to fail the proportionality test?
Right. Well, that's a lot to take in. No, I didn't see that question. Well, of course, it will go back to the Belgian court to decide this. And I guess on the question of restriction by object, as I said earlier, I don't see it as a restriction by object. You might come to the conclusion that it prima facie, it looks like a restriction by object, because what you're doing is you're limiting the market, particularly for the recruitment of players. And the more you limit it to a national market, the more you should be evening out issues such as competitive balance, although that wasn't raised in the court. It was really on the incentivizing the younger players. But it's the desire to incentivize and intensify the training of the young players that is at issue there. So the restriction on the clubs in terms of their recruitment opportunities is an effect of that. And then you could look, and even if you not prepared to accept a Mecca Medina type analysis, you could then look at the issues around efficiencies and who benefits from those efficiencies, and the question of proportionality. And I think what was interesting is the court didn't undermine the ability of a governing body to adopt such rules. And indeed, somewhere in the judgment, it talks about the ability to endow the market with a national character, which is what the homegrown player rule is effectively doing. But that national character doesn't partition the market. It doesn't partition the market like, as in the QC Leisure case, the Murphy case, where it was basically exclusivity agreements, then with territorial tying, which was partitioning the market along national lines. This rule isn't doing that. It's only doing so in a limited sense. And in terms of the evidence required, I mean, I know the court talks about wanting to see convincing arguments and evidence, but it also goes on to say that it wants to see a rule that establishes, I think it says, real and significant incentives, but then says in a certain of young players, without having to ensure in a certain and quantifiable manner in advance the efficacy of these measures. So it seems to be a little bit of doublespeak there. It's saying that it wants evidence, convincing arguments, but these don't need to be presented in advance. And so it will be, but given that the homegrown player rule has now been in operation for a number of years, one would have thought that the National Court would want to see harder evidence than just abstract arguments that, well, this is likely to intensify training. Presumably there is sufficient evidence of that now. One problem with that is, how do you disaggregate the influence of the homegrown player rule? Because one thing that I remember from that study, when we conducted a number of interviews with clubs and sporting directors and people, they were saying, well, yes, we invest a lot in youth development, but it's got nothing to do with the homegrown player rule. It's either the local economics of the situation, it's the club ethos, it's a whole range of other factors. And how a national court can disaggregate that, I don't know.
This, leads me to the point that I'm really, doubting about, not doubting, but I just would like to know what are really if the legitimate objective is the training of players and, incentivate clubs to train. Is the homegrown player rule the proper rule to compensate the clubs, incentivizing the clubs to train young players? I have my opinion on this, but we will organize another meeting, another webinar only for this. Thank you so much, dear Richard. A question from Boria. I think that could be both for Stefano and Maria Carmen. I don't know if you can read the question. Boria is asking, could we read the court's belligerence towards Article 165 and the EU sports action as wanting to push back the councils and even commission a recent political declaration or agreements, at least until they decide to legislate? So basically, is the court fed up of soft law? So if I read it correctly, it says some contrast, between institutions.
Michele,
yes,
say something,
please.
I think that the question is it's very important. Thank you, Borja, for putting this question. Durante Rapacciolo wrote a very recent paper where he argues that the rulings of the court represent a message to Mr. Rantos, to the EU institution, and to the Sporting Federation. I agree with Borja as far as the Court of Justice is saying something to the other institutions. I think the reference is to the declaration by the Council and the European Parliament on the European sports model. I can imagine the Court of Justice referring also at the old UEFA and EU agreement on the financial fair play and state aids rules. So I think there is a clear message in that sense. But I don't know what Borja means when it refers to at least until they decide to legislate. He knows better than me that under Article 165, no harmonization measures is possible. So I think that until sport is under Article 6 of the treaty, I think that we could see only soft law. That's my point of view.
Michele, if I may, Borja can't speak, so I don't, and I would never dream of speaking on behalf of Borja, but maybe what he meant was that I mean, what's the court is basically saying that the member states establish this competence. Don't ask us to expand it, which is a bit odd because we always thought that the court was judicially active. If the member states want Article 165 to do more than it is currently doing, well, it's for the legislature to decide that. And maybe that's the point that Borja was making.
Thank you for clarifying this. And I don't know if Maria Carmen.
No, I was going to say I agree with Richard and Borja. I think the word legislation in the question means if you want to have a hard sports policy, you can change the sense of the competence, the nature of the competence, of the competence you attributed to the EU. Is not, I don't know if the court is fed up with soft law, but it's saying I can do more because this is the competence you gave to the EU institutions, US member states, because he refers to the drafters of the EU treaty several times in the judgment.
Very good. Very good. And I see Antoine. Antoine, you raised your hand, please.
Yeah, no, I wanted to also jump in that discussion because I think I think it's and it's not on my arbitration limited area, but I think it's an important discussion, and I do think that share the view of Stefano that I think the court is not talking only to sports governing bodies. It is, I think, asking the EU legislators, and in particular the Commission and the Council, to move forward if they want to ensure that a certain European football model is preserved. And that it is saying that it is not its role to do that. Where I maybe differ a little bit from Stefano is I think obviously there is no competence under Article 165 to legislate, but there is a competence under internal market rules. And in this case, this is clearly an economic activity that is transnational, and that seems to be necessary to legislate at the transnational level. That's why we have such a prominent set of transnational regulators like UEFA and FIFA. So, and I'm not the only one to say that. I mean, here Miguel Maduro, Stephen Weatherhill have long been advocating for the EU legislator to get into the fray, not under Article 165, but under the internal market competence, and to regulate football as an economic entity, and to create a separate agency to govern it. That might be an interesting option. And I think that might be a direction we could go towards if, and here I connect back to Massimo's point, if those cases create chaos, if those cases create quite a lot of challenges with a lot of uncertainty at the national level, many preliminary references, we might get towards a situation where the legislators will be forced to intervene, and will be forced to intervene not necessarily under the sports competence, but under the internal market competence.
Sorry, Antoine, may I ask you something? I mean,
Sure.
Yes.
Is your point of view that sport as an economic activity is no more under Article 6 of the treaty? Because Article 6 says what is the competence of European Union in the field of sport, culture, youth, and so on.
Education.
So if you're saying that probably when sport represents an economic activity, the EU legislator can legislate under the internal market rules, we are, in my view, we are moving the sport as an economic activity outside Article 6 of the treaty. And so we should read sport in Article 6 of the treaty as meaning only amateur sport, recreative sport. Is it your idea of I am mistaken?
I definitely think that that could be a line of argument that you could advance. Indeed, that amateur sport and professional sports are two different types of activities that really raise two different types of problems in terms of regulating certain markets, for example. And that certain sports, for sure, football, for example, are massive European-wide economic activities that necessitate an intervention of the legislator under its economic competences. And again, I'm not the only one to make that case. And I think it could hold before the Court of Justice. That would be for the Court of Justice to decide in the end whether this is a legitimate interpretation or not of the competences of the EU. But I think the case can be made. Yeah.
Very good. Oh, please, Stefan.
I just say thank you to Antoine.
Okay, and let's conclude. I mean, I think that we just have a couple of questions left. Yeah, conclude with you, Massimo. I want to
not to conclude, but just simply two points on the legislation. I think the trend is towards the member states trying to limit EU regulation. So this is the trend in the last year. So I see realistically, I see it very difficult. The intervention, apart from the legal issue that of course there a problem, but I see it difficult. Realistically, politically, I see it very difficult. Then another point is was a question put by Nina here, and we didn't answer. Yes. About the calendar. She says correctly, how do you comment on UEFA's argument that new competition, i.e. Super League, will disrupt the already established long-lasting competition calendar? Didn't the choice of Qatar to host the last World Cup do exactly that? She's absolutely right. But the point is that I want to make is that calendar is a very, very, very important point. If calendar is left to the sports governing bodies of the various sports, then it's very difficult for alternative event organizer to organize competitions. So there is a problem, very serious problem with that, because if it's the entity who is the gatekeeper for alternative event organizers, who also decides the calendar, it's very easy to place all the competitions in a way to make it very difficult to have enough room in the calendar, taking into account the need to protect the health of the players, because that's a very important concern. Because if they play more and more, that's in football, but we see that also in other sports. Their health is at risk, and so the fact that the calendar is already crammed make it in practice very difficult to establish new events by alternative event organizers if the calendar is left totally to the sports governing bodies. So there should be a way out of that. And I remember the calendar, by the way, talking about the ISU case, was one of the points that were mentioned by Commissioner Vestager in her statements about when the Commission decided about the ISU, saying that sports organizations should take into account, the different situations before establishing a calendar, and so that's a very important point raised by Nina. And I see a lot of litigation coming in concrete terms because with that.
Very good. So I think that Nina, thank you so much for your question. Just because I think that we have just one question left from Ismail. I think it's for Maria Carmen.
Yeah, I read the question.
Yes. Before. What do you think?
Yeah, 1 minute. what I think is the ruling of the European Court of Justice is binding upon the national court as far as it interprets EU law. I mean, the interpretation made by the European Court of Justice of EU law is binding, but it's for the national court to apply this interpretation to the concrete case. So the result depends on the interpretation of the interpretation made by the European Court of Justice, which is not, in my view, I mean, like adding 2+2. I mean, you have to work on the case, and it depends on the result of the reasoning. So I don't know about the second part of his question. I don't know which would be the final decision of the national court, but the ruling is binding as far as it interprets EU law.
Dear colleagues, dear friends, dear panelists, dear attendees, I'm so happy to have had this beautiful webinar. I'm so thankful to all of you for having participated. So thankful to the Italian, the Spanish, Portuguese Sports Lawyers Association, and also to ISDE, SSBM, the Collegio Europeo di Parma, the University of Bergamo, for this beautiful event. I'm so happy that it's over. Now I'm going to sleep, hopefully to sleep for hours.
Peacefully.
Thank you so much. Thank you so much to all of you. Keep posted. We will be organizing events, publication again on this beautiful, fascinating field of law. Thank you so much. I love you all. Bye. Ciao, 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 ciao.
Thank you. Bye-bye.
Thank you.
Ciao.
Thank you, Michele.
Ciao, ciao, ciao.
Good evening to everybody. Ciao.